But here, you know. Hi, everyone. Hello. Hi. Came all the way from SoCal, right, to come to this talk. People have come far, far a long way. Well, happy Thursday, everyone. Thank you so much for joining. I think I know everyone here, but if you don't know me, I'm Jenny Locke, and we're the Zen Coast Homes team, and we're super excited to work with John Martin here, and he's an amazing estate and trust family planning attorney who knows a lot of different details. He's been in industry for almost 2 decades plus and has spoken around the whole country and be able to share his wealth of knowledge regarding investments, regarding protecting your assets, regarding avoiding probate, which he'll go over if you don't know what probate is. And we're super excited to dive in. So I just want to get a lay of the room here of who owns a home here. Raise your hand. Tony, you don't own a home? Well, we got to get you into a home soon. And Jen owns a few. I think, who owns multiple properties? So multiple, great. And then who owns properties out of area? Okay, so a few out of state. Helena just closed on hers. Yay, where's yours? Tampa, yay, congrats. So cross country and all that. So we want to make sure that you protect all your assets, not just here in California, because the regulations might not just be here, but then if you have other assets in other states, although you might have a trust set up, you might still go through probate in another state. So we're going to make sure you have all these assets protected. You worked really hard for your down payment to save all this and be able to build your wealth. So making sure you avoid any issues that might arise, and you don't want the government to take all that money away from you. But just a little bit background on who I am. I graduated USC Marshall School of Business and had a passion of investing in real estate. I bought my first home at the age of 23 years old here in the Bay Area. I house hacked, rented out rooms, and I was like, this is awesome. I was working at Oracle not too far away and wanted to teach other people on how to do the same. And got into real estate. I initially got into real estate as an investor mindset, but ultimately fell in love with being able to help people purchase their homes, be able to add value to their next homes, be able to scale and grow and build their wealth and their portfolio. So currently we have over 380 units in our portfolio with me and my husband. We run a community called Zen Coast University, which a few of our members here are, which we teach about passive income and being able to create massive impact. And something that we are really proud of is that last year we were able to host a charity gala and give back. John was there, and we were able to give back over $50,000 to charity nonprofits across the nation to be able to help with natural disasters such as the Maui fires that happened, be able to help with veterans who had no purpose in life after they came back from serving. Are you veteran or thank you for your service? Oh, well. Well, we'll show you some purpose or something that we have another program called Ikigai on and be able to just help people around our community here. And we just launched a company called Zen Coast Cares, which is on educating middle schoolers and high schoolers on financial literacy and teaching them assets versus liabilities. When I was in middle school, I actually flipped sneakers and build my wealth from that to be able to sell sneakers so I can go to study abroad in the future. So we want to teach kids at a younger age on this. So we're so grateful you spent your Thursday afternoon to come learn here, because we always say like you're growing or you're dying. So at your age, there's really important to constantly feed yourself information, even though you're not in college or school anymore. So been my real estate investing journey, bought first house in 2016, invested that and leveraged and bought more and scaled over now 300 units. And my big why was to be able to move my parents here to the Bay Area, and just did that a couple of years ago, and they live with us. And it's really important now we have built this whole journey to protect everything, because if something happens, someone, a DoorDash driver comes and trips and falls, like you don't want them to take over all your other assets and take everything that you worked so hard for. And this is our team. So if you don't have some properties like Tony, we're excited to help you. We help with buying and selling and investing in real estate here in the Bay Area. And if you're looking out of area, we have a whole network called Zen Coast University to teach you on how to do that and can connect you with our partners across the country. And just a quick benefits of investing in real estate is the tax advantages of real estate. Actually, I was talking to John earlier of how we were able to leverage cost segregation and depreciation and be able to save multiple six figures in taxes from owning real estate, but ensuring that they're properly protected. You also get property tax deductions of your primary home, and then mortgage interest deductions, $750,000 for your primary, and up to all the mortgage interest deduction for your rental property, and also capital tax free gains. So if you buy a house for $1 million, you sell it for 1.5 million, you get all that 500,000 tax free, which is amazing, and then roll it into the next house. Great appreciation. We're seeing appreciation consistently go up about 4% here for single family homes in the San Francisco Bay Area. And it's consistent monthly payments, and you build a lot of equity over time. So I started at 23, I'm 31 years old now, and was able to scale from nothing to over $10 million of real estate. So we want to be able to teach you on how to do that, but it's important to protect it too. And these are just some of the families we helped. And selling trust homes. So luckily Donna, she inherited a property, and her dad passed away and had a lot of stuff in the home, and wasn't sure what to do with it. But luckily she had a trust set up and was able to be the executor and spread out all the different assets over time. We had another seller who mom and dad did not have a trust set up. And then one of the siblings was schizophrenic, and then he was trying to get a lot of the assets afterwards, and he had to move out of the house, and he had to get a high loan, like 20% loan, to be able to live his life, because he was waiting for the courts to be able to sell the house, because it was held in probate for over a year, 2 years. And even after we sold the house, it still took some time for them to get the money and the proceeds. So that's where you don't want your money tied up, or your, if you have family members, parents and grandparents, it's really important to have this conversation with them to see, hey, mom, dad, grandma, grandpa, auntie, uncle, do you have a trust set up? I just went to this amazing seminar with Jenny and John, and we learned about this, and I just want to make sure that we have our assets protected. So we want to save you, it can save you hundreds of thousands of dollars, if not more, of time, headache, and everything. And I'm excited to bring up John Martin here, and he'll give a great introduction, but he's been able to help a lot of people and dive into this.
Thank you. Well, thank you so much, Jenny, for that introduction. And I just want to say thank you also for inviting me. I've been really impressed by Jenny, her drive, her determination in building her business. It's an incredible story. And also the professionals that she surrounds herself with. She actually did refer me to her CPA, which is one of the professionals she works with. And immediately he was able to save me some taxes with the depreciation schedule he put together. So she walks the talk, and it's really impressive. So thank you.
Thank you.
Yeah. So I wanted to talk today, obviously, about estate planning. But what I wanted to do was both some basics, but then as we move along, have some more complicated things that we build it into it. I know there's probably a range in the room, people who've never done any estate planning, people who've done estate planning, people who've done complex estate planning. So there's going to be some gems for everybody along the way. And I hope that at the end that you have something that this sparks something for you. You learn something. Maybe there is some risk, something in your life, your financial life, that you didn't realize was a risk. And so you're now going to be able to have, I hope, some tools at the end of this where you'll be able to identify that and protect yourself, your family, your loved ones from a loss of wealth for yourself and for others. So let's come up with a working definition of what we do with estate planning. There's a lot of confusion around those words, estate planning. You know, is that planning for somebody who has like an estate in England or something with all the hedges? No. The estate is everything that we have in our lives, our personal financial things, our personal health decisions. So we're looking at wealth transfer planning, and then we're looking at those people in our life that you're transitioning wealth to, your beneficiaries. That's the legal word for the people who you love in your life, right? Your spouse, your children, the charities that you have, your friends, the more remote relatives that you might have your estate go to. What happens when the wealth goes to them, right? Whether now or in the future. Will it be spent well? Even if you are okay with it not being spent well, what if it gets taken by a divorcing spouse or by a bankruptcy court? Then have you accomplished your goal of preserving wealth? So we're looking at multiple things within that. This is obviously too small to see, but for you to know that within each of these things, there's subcategories. So with wealth transfer planning, we're looking at different kinds of ways to save expense. And with expense, there's going to be so many different kinds. There's taxes, there's administrative delay. One of the things that Jenny mentioned earlier was what we call the big bad P word, probate. People are trying to avoid probate. People also, when they first are exposed to estate planning, are in disbelief at what probate really is, because they think, how could this be the default? How could this be what the government has planned for me? This seems impossible. Let me tell you what it is. It is the administration of your estate at your death through the court system. And if you don't do planning, if you don't do what I'm describing today, this will be what happens to you if you have an estate that's above $184,000. That's the threshold. The government will charge starting at a 4% fee of the gross value of your estate. So that's not looking at any debt or leverage you have. Think about all of your assets, and then there's just this fee that goes off for just processing your estate through the court system. This is a 2-year process right now in Santa Clara County that we're finding. It used to be a lot shorter, but after the pandemic, it takes about 6 months to get a court hearing. So imagine waiting 2 years for your children to get the estate after you've passed on. And it's public. Could you imagine in your life, there's been people maybe you thought of as gold diggers, people who go in and they try to take advantage of a relationship? Well, do you know that there are people who could look up and see online for free what your children are going to receive or what your loved ones will receive? It's public record. Imagine that, an invasion of your privacy. So these are some of the things in wealth transfer planning we're looking at: avoiding probate. We're also thinking about estate taxes. I'll get into that in more detail, about preserving the wealth. For beneficiaries, we're thinking about preventing lawsuits, preventing the effects of divorce. For incapacity, we're thinking any situation where you're not able to manage your personal or financial affairs. And we have a lot of planning around that. Now, as we continue to distill and focus, what I want to look at today is 4 goals around the wealth transfer planning, because Incapacity planning, wonderful. I'm not going to focus on that today. You know, definitely very important. Healthcare directives, powers of attorney. Maybe looking more at the wealth transfer planning. And I would talk a little bit about beneficiary protection. So goal one, avoid that administrative delay, that 2-year process, that starting at 4% of your gross, and it actually could be even higher than that, as we're going to see in a second. And then we're going to look at minimizing or eliminating estate tax, minimizing or eliminating reassessment for property tax purposes. And as a bonus, I'm going to talk a little bit about asset protection using business entities. And then goal 4, protecting and preserving assets for future generations. So when we're talking about avoiding administrative delay, you first want to, and avoiding taxes, you want to think about, well, what is your estate? What do you own? So this is everything that you own in this larger box right here. But only a portion of that is going to go through probate. And this is already the key to avoiding probate, is knowing what's subject to probate, but what's in your estate that doesn't go through probate. So things that go through probate are anything in your name individually. Think real estate that's in your name individually, or think joint tenancy real estate, but both of the joint tenants die. Think bank accounts, think tenants in common property. Have you ever seen property owned by multiple people and there are tenants in common? So regardless of who passes away, you know, that interest is going to have to go through probate. And community property at the death of both spouses. But assets that are owned by you may not go through probate if they have a beneficiary. So that could be a transfer on death beneficiary. You know, retirement plans, IRAs, 401ks, these are government regulated plans. Those pass to a named beneficiary. And actually with your 401k, there may even be an automatic beneficiary that's assigned by your plan administrator. And then the federal government even regulates who you can name as your beneficiary. You actually have to name your spouse. I thought it was a free country. Can't we name anybody? No, the federal government says you have to name your spouse unless they sign off, and then you can name somebody else. That's a lot of protection. I'm sorry. Which spouse? The one you're married to currently. Yeah. So then you've got joint property. So, you know, a deed would name somebody as a joint tenant. That actually, when one of the joint tenants passes away, it does pass automatically outside of probate. Assets in trusts. And so we're going to talk about that a little bit in more detail. Now, things that aren't owned by you, and we're thinking about things that aren't going to be taxed at your death, things that you've already gifted, you know, if you've gotten it out of your estate. So things that you've given to your child or to a spouse that you don't retain any ownership in, that could be an irrevocable trust. So like if I have life insurance, but it's owned by an irrevocable trust, it's not going to be taxed in my estate at my death. But if I own that life insurance at my death, $5 million policy, it is going to be taxed at my death. And a lot of people overlook that. Yeah. So we're going to think now about, okay, trust, because I mentioned, okay, this is everything you own. Some of it goes through probate. We don't like probate. That's the big, bad, ugly P word. It's 2 years. It's expensive. By the way, how expensive, you know, it's kind of hard, even 4%. What does that even look like? I quoted out somebody, it was a $10 million estate. We were going to have a $400,000, right, probate fee. So imagine that's just for processing these documents through the court. Does that seem like a ripoff? But it's just in the law. It's just written there. It's like, you know, insurance for attorneys. So you've got trusts that can avoid probate. What is a trust? A trust is a document, but it's also a legal entity. So, you know, if you've ever formed a legal entity, a corporation, an LLC, you know that you go to the Secretary of State of whatever state you're in and you register it. And then now you've got a tax ID number and you can have a bank account in the name of your company. You know, Warren Buffett is a big shareholder of Coca-Cola, right, through Berkshire Hathaway. But when he dies, and I'm afraid to say that he is eventually going to pass away, and Berkshire Hathaway will continue under somebody else's name, Coca-Cola, though, will continue to exist, right? Because it's an entity that has a separate existence from Berkshire Hathaway and Warren Buffett. And the same is true with your trust. You set this up, you fund it, and it still continues to exist if you become incapacitated or pass away. And that's why it avoids probate, because it's not in your name. It doesn't pass through the system. But unlike a corporation, you don't have to register this anywhere. It's very unique. A lot of people say, do I have to file it with the state? You know, is it a public document? No, it's just a document that's in your file. But then you can take title to assets. Seems almost a little scary, you know, and It is. I've seen properties that are owned in a trust, that person dies, we don't know where the trust is. We still have to go through probate. So you may have to do more than just have a document in the file. You might have to have a system for finding that document if you were to pass on. But as I mentioned, it avoids the public seeing your asset because it is that private document in a file. And of course, because you don't have to go through probate, these assets are going to be able to pass at your death through the trust in the privacy of an attorney's office or in your children's homes, right? And maybe within just months, they can pass the wealth to your family, right? Rather than years. So we've just accelerated the process. We've stayed out of the court. We've minimized costs by setting up this trust, maybe hundreds of thousands of dollars that you're saving for your family. And when you hire an attorney to do this, it's really just a few $1,000s typically that you're paying the attorney. It just seems like everybody should do this. This is adulting, right? You get to a certain point and then you're like, I'm going to get a trust. And when you see people who hold property not in a trust, that's a key, say, oh, maybe we should go and set up a trust because real estate, remember, it's the gross. A lot of people have mortgage loans, going to be probate fees on that gross value of the real estate. So we talked about avoiding administrative delay, and now I'm going to go into another area, which is minimizing or eliminating estate tax. Now, first of all, what is estate tax? Back in the 70s, used to be that people were all affected by estate tax. You could only pass like $40,000, $50,000 to your kids, and the rest was taxed at the super high rate. I don't see anybody who I think would have remembered that. We have a younger crowd today, which is cool. But wow, what a change in the law. Today, you can pass $10 million inflation adjusted to your family without any estate tax. So a married couple, $20 million inflation adjusted. So most people are not affected by estate tax. 27.2 million with inflation. This is indexed going back to 2012. And unfortunately, that is part of a tax reform bill, the Tax Cut and Jobs Act of 2016, which is scheduled to sunset or expire at the end of 2025. This was the Trump tax bill, right? So the lower tax rates, the higher standard deduction, the SALT, loss of the state and local income tax deduction, all that's going to expire at the end of 2025. And we're going to go back to a $5 million per person inflation adjusted exemption amount. So we have a lot of clients just being in this area that are what we call the danger zone. The danger zone is where you maybe have an estate below 27 million for a married couple or 13.6 million for a single individual, but it's above 5 million inflation adjusted, owning a house, having a 401k. We see a lot of people in that category. So that's unfortunately the danger zone with estate taxes. And we'll talk about how you might be able to deal with that. I will tell you that there is a political component, and I'm just saying this as a bystander. I'm not making any political comment when I mention this, but Democrats want to bring that amount even further down. So when Hillary Clinton was running for president, she wanted a $3.5 million exemption amount. Something to be aware of that President Biden never had a specific number that he proposed. He just said he wanted to bring it back to what it was. So we do have on our potential scenario list that $3.5 million exemption could be in the works. But if nothing happens, it would go back to that $5 million inflation adjustment amount come January 1st, 2026. So there's also some what we call anti-clawback rules, which is that after this Trump tax reform was passed, people were really concerned, well, what if we use up the exemption amount now? And actually, it's a little detail that, you can gift now, and anything that you gift now actually comes off of your exemption that you have at your death, right? So it's not like you can avoid estate tax at your death by gifting now. If you gift now, the IRS keeps track of everything over $18,000 per person that you gift, and then that you have to file a gift tax return. It's called Form 709. Then they have a running total of all your gifts, and at your death, it's that much less you can use. So what if you gifted your whole exemption amount of $27.7 million? Then will you be taxed when the law reverts to what it will be January 1st, 2026? No, and they passed regulations saying that they wouldn't be able to claw back the gift that you made and apply the new law retroactively. They actually ensconced that into the wall. I think that's great because it gives people the confidence to know that they can gift now and be able to use that exemption. So we have a lot of people who are, $50+ million estates, and they're saying, hey, we want to gift some money right now to our children. And I'm like, are you sure? They could end up being losers. I don't say that word to any parent. Are you kidding? I would never say that. I would say, well, you can't take that money back. So you do want to be confident with, of course, your children's ability to properly spend those funds, and use them, since you won't be able to take those funds back. You don't own them anymore, right? You can't spend that money anymore. So are you sure you want to do that? Okay, you do. All right, well, there's a great benefit of doing that, because then if you die after January 1st, 2026, then you just used your exemption amount and they can never take it back. You used it and you get the benefit of today's law. So there's another thing that you should know, and this is the greatest tax benefit you will ever get, but there's a catch. You have to die to get it. Sorry. It's the step up and adjustment in cost basis at your death. This is under IRC, Internal Revenue Code 1014, the greatest tax benefit you'll ever receive. We were talking about buying real estate. You got a cost basis in your real estate, and as you sell it, you have to pay capital gains taxes. Nobody wants to pay capital gains taxes. They're depreciating, and so they end up doing tax deferred exchanges, right? You just keep on deferring the tax. My dad was a financial advisor. We'd get around the table at night, we'd be eating dinner, and he'd say, John, defer your taxes. I'm like, thanks, Dad. It's a wonderful life lesson to defer your taxes. And 1031 exchanges allow you to do that. And then when you die, you will actually get all of your cost basis adjust to the fair market value as of your date of death. But guess what? Politicians want to take that away as well. They want to make it so there won't be any step up in basis at the time of your death. And in fact, they even had introduced a bill, this was a few years ago, where they would say, even if you don't sell your property, you have to pay all the capital gains tax in addition to the estate tax. I think that sounds crazy, but they didn't have enough support, even among Democrats. There were several senators that didn't want that passed. So I don't think that's going to come. I think we're still going to have a step up in basis, because there's a lot of political support to have a step up in basis at the time of death. It's because those senators are so wealthy. And so they kind of are self-interested. It's true. So what does this mean for you? You're going to use it now or you lose it later. However, step up in basis, maybe you thought about this, maybe not. If you have a non-taxable estate and you've gifted your assets, remember back to our chart, what do you own at the time of your death? Anything you gifted, you don't own anymore. You connect the dots to, hey, when you die, anything you own gets an adjustment of basis. So if you gifted your assets to somebody else, you're not going to get a step up in basis for those assets. It's actually better to retain your assets if you have a non-taxable estate, because then you get the step up in basis. So I get a lot of people who did live through the 70s and did know that time when there was a really low exemption amount, and it was always a good deal to gift during their life. Now that's not true. If I had somebody who has a sub $10 million estate and they're like, I want to give the family farms, but I don't have clients with family farms. I want to give the home in Palo Alto to my kids. I'd say, don't do it. Keep it, because you're going to get an adjustment of cost basis at the time of your death. And that's a way more important tax benefit than getting the higher exemption amount today, because who cares if you're going to get the $5 million inflation adjusted. So what if you do want to save on estate taxes though? What strategies do you have? We have a lot of different strategies. I will tell you, I've had estates where people come in and they're like, I guess I'm going to have to pay estate taxes. And for most people with like $100 million, that's true. But if you're more in like the 30, 40, $50 million range, we can actually do a lot. We can, and especially if you have runway, like you're in your 40s, 50s, we can start transitioning wealth over time to your family members gradually. And we have trusts that can do that, grant or retain annuity trusts, ILITs, life insurance trusts. We could potentially eliminate the tax altogether. Although for people who have larger estates, I say, no problem, we can eliminate the tax, but you do have to be charitably minded, because give it to charity, there's no tax. But then it doesn't go to my kids. Well, yeah, that's true. But you could set up a charitable foundation and name your kids as board members of the foundation, and then that's okay. All right, so how can you preserve wealth? Now, we're also talking about this in the context of property taxes, because remember I mentioned wealth transfer planning, and I talked about administrative delay, estate taxes, income taxes. I've now talked about all of those. For Californians, there's one additional layer that's super important, and that's property taxes. You guys know about Prop 13? This was also passed back in the 70s. I've been mentioning the 70s a lot. That was a big decade for California. We had tax revolt. There were all these angry taxpayers who were saying, no more new taxes. So they passed a constitutional amendment through proposition, which was Prop 13. Prop 13 says that your property taxes cannot increase by more than an inflation-adjusted 2% each year. So if you buy your home in 1973, when Prop 13 started, your taxes would have increased a maximum of 2% per year. I have people who literally own $10+ million homes, and they're paying a few $1,000s a year in property taxes. And you might say, well, that's not fair. On the other hand, they're like, oh, I would have had to move out of this beautiful home had I been reassessed. Okay, well, it's your version of fairness. But I will tell you that under the old law, so prior to Proposition 19, which was passed in November of 2020, you could also pass that tax break onto your kids. And it was not just your personal residence, it was all other real property too. So for example, you had a commercial property, you had a rental property, you had a vacation home, you had your residence. No matter what the value of your residence was, you could pass that to your kids. That $10 million home, whatever the property taxes, could go to your kids, no reassessment. Plus, you could take the first $1 million in assessed value of other property, send that to your kids, no reassessment. After Prop 19, they severely curtailed that. They got rid of all the great benefits, except they said an owner-occupier could pass to an owner-occupying child a residence, and the first $1 million in fair market will be accepted from reassessment. So very hard to meet that criteria. Yeah, question. Yeah. So let's say like you got a grandma, she's living in the home, right? And it's $1 million, this Goldilocks scenario. And grandma dies and she leaves it to her daughter, Sally. And Sally moves in and she lives there the rest of her life. And it's a $1 million home. There would be no reassessment. I've never seen a Goldilocks scenario. There's always more than one child. Children can't share a home. What are you gonna do? You're gonna split the home and like half, like your sibling and their kids live on one side and you, maybe people do that. I don't know. I'm not as much in the Bay Area. Do you know anybody who does that? But then also, so then you have to buy each other out. Well, the buyout causes a reassessment because there's no sibling to sibling exception from reassessment. So you're going to end up being taxed more. There's also the problem with that million. Most people's homes are worth more than $1 million. So it's going to be reassessed for the portion over $1 million. Most grandmas don't live in the home through the date of their death. They move into a care facility. So now they're no longer an owner occupier. I get a lot of kids that say also, well, what if I move in for a year and then move out? Sorry, the county is going to reassess you as soon as you move out. It's not like 1031 exchanges where you can do a 3-year safe harbor and you're good. You have to stay in there. However, we do have a very important, yeah. Yeah, and I'll take out grandma because grandma kind of, screws with the example a little bit. But let's say I'm 55. I'm actually already looking forward to 55 just for that tax break. I'm thinking, oh, I could move over. I got 15 years ago, but I can move over my property tax basis. Like, wow, that's a long time to wait though. But once you're 55, you can sell your home and move your property base year value over to a replacement home. Now, there would be a reassessment though for that portion of the home that's over the sale price of your prior home. So a great example, Goldilocks scenario, you've got a $3 million home and you're paying on a $1 million base year value. A $1 million base year value would be you're paying $10,000 per year in property taxes because your property taxes is set at just over 1% of whatever your base year value is every year. So then you sell that home and then you move to where do you want to move? Malibu? Mountains? Has to be in California. No Nevada. You can move to Nevada, but who cares about California property taxes? You're paying property taxes in Nevada. So you buy in, a mountain district in Placer County, and you buy a $3 million ranch. So you don't change your property taxes, it stays the same. But let's say you buy a $5 million property, okay, they're going to take that $2 million in overage. That's $20,000 per year. They're gonna add that to your $10,000 per year. So now you're paying $30,000 a year in property taxes. That's how it works. There's actually, I don't know if you ever use Fidelity National Title or Chicago or First American. They're all actually owned by not First American, Chicago, Fidelity, there's one other. They're all owned by the same company. They have a calculator available on their website. You can go in and play around and like, oh, what if I sold my home and bought another one? And they'll tell you what your new property taxes will be. But let me tell you, there is hope. There is hope if you wanted to still pass on real estate to anyone, not just a child. This could be co-occupying couples that are not married. This could be grandparents and grandchildren. This could be brother and sister who did divide up the house and they've spread out, their families to various rooms. No judgment, that's totally cool. But you can use this strategy in order to avoid property tax reassessment upon passing it to the others. I just used this strategy today. I had a client who called me up. She said, okay, my husband passed away. I'm splitting my home with my stepkids and I want to buy them out. I'm like, I don't blame you. I would want to buy out my stepkids too. She's going to take advantage of this strategy, which I'm going to go over with you right now. And that is that we combined two exceptions that the California Association of Realtors, I hate to say it, but Prop 19 was written, no offense, I love realtors. California Association of Realtors wrote Proposition 19. Do you know why they wrote Proposition 19? No offense. They wanted to get more sales. Because if you're forced to sell residences when your grandma dies, that increases commission. Sorry, I'll move on. I don't like, Okay, so two different exceptions still exist. That is that you have a business entity and there's a minority interest transfer of that business entity. That's not going to reassess any of the property that's owned in that business entity. We had a lot of people that raised their hand when they said they own real property, right? Maybe you own an LLC. If you gave 2% of that LLC to your kids, there's no 2% reassessment of your real estate in that LLC, right? Because there's no change in control. The law says it will change control. All the real estate owned in that entity now gets reassessed. So imagine you have that rental property, it's in an LLC, and you give 2% one year and you give 2% the next year, and you keep doing that every year until you get to 51%. And then boom, everything in the entity is going to reassess. So this is actually kind of scary, right? Because we got people who aren't tracking what's in their gift plan and their gifting, and then suddenly they get this new tax bill in the mail. So we track that for people when we're doing the gifting. But I'm going to show you how we can use this to our advantage. There's also something called proportionate interest transfers. That is, if you own that rental property and you have it in your trust, and your trust is the 100% owner, and now you set up an LLC that's owned 100% by your trust, and you move that property that's 100% owned by your trust into an LLC that's 100% owned by your trust, there's no change in the underlying ownership of the property, right? I used a lot of words, but that's pretty clear, right? No change in the underlying ownership. Because the owner of that LLC is the same as the owner of the property. That's called a proportionate interest transfer, and that works both ways. Take something out of an LLC, put in the trust, proportionate interest within the LLC from the trust, proportionate interest. Let's say you own something with another owner, 50-50, right? So two siblings, they own a house, 50-50, undivided interest. They put their property into an LLC, own 50-50. Proportionate interest, no reassessment, they take it out, no reassessment, proportionate interest. Let's say they own the property 50-50 and they put it into an LLC owned 51-49. Does anybody want to guess what happens? Completely 100% reassessed. I think that sounds unfair. I don't like the way they wrote that law, but that's the law. You transfer something that's not exactly proportionate interest, 50-50 to 50-50, 51-49 to 51-49, it's all going to be reassessed, but we can use this to our advantage. What we can do is, now don't attempt this at home because I was describing how, risky it is to do something where it's not, yes? You may.
Trust to LLC.
Yeah.
What if you got married in between, but then you still have a LLC under your name? Like, what's the implication with your spouse? Because under law, you co-own everything, but then that's prior marriage.
Au contraire, Emily, you do not co-own everything with your spouse. We live in a community property state. Community property is everything that you acquire with your earnings while you're married. But everything you bring into your marriage from before you were married is still your separate property. If you're Barry Bonds went through a really messy divorce. Barry Bonds brings $100 million into his marriage, and then his wife divorces him the day after. She gets zero. It's all his separate, right? You wait 10 years and you earn $100 million. Now you're splitting the $100 million 50-50 with your spouse. No, what you do is you move to New York, and then there's a 3-year waiting period, and then you can be divorced under New York's laws, but I digress. So, so what you want to do, how you use this strategy is this. Again, don't attempt at home. You want to pass on some interest in real estate to your kids, call it 100%, right? You own this property 100%, right? Now, what you can do to avoid reassessment is you set up a legal entity that you own 100%. Then you gift up to 50% of that to the next generation, right? To the other siblings, your kids, whoever it is. Then you stop. And then you do a proportionate interest transfer. Remember, 50-50 to 50-50, no reassessment. And you stop. And then you wait a little while, maybe you go to the next tax year, and then you gift outright 2%. Now, the way they do it for outright gifts, not entity gifts, but outright gifts, is they look at what's actually transferring. What's actually transferring on title is 2%. So they reassess you 2%. Who cares? 2%, $5 million, it's nothing. So then you form a new LLC. And now this one's owned 48 by you and 52 by the kids. Now you do proportionate interest transfer to this new LLC. Stop. No reassessment will occur at your death. Why? Because you don't have a controlling interest in the LLC. I could have just done that for $25 million in real estate. I did just do that for $25 million in real estate. And my client was ecstatic because she said, I was going to have my kids sell these apartment buildings. Because you just did this, John, my kids can continue to run the family business that my husband and I worked so hard to build up, all these rental properties. Thank you. So this is something that you can do for your family, for your loved ones, but don't attempt to home. I thought I saw a hand. Yeah. Epiphany?
Good. Well, all become like really good at hiding our money.
That's not hiding.
Then like who's gonna run the country? Like they would have no money, right?
Who's going to run the country? The same people that are running it now, the people who are doing the same. I'm not going to tell you who was in my office the day that Prop 19 got passed. But let me just say that all the people in Washington and Sacramento are the people doing these things. And let me also say this other thing. The guy who's the chief reviewing attorney at the IRS for estate and gift tax returns has my same last name, but he's of no relation of mine. Kyle Martin. Okay. Kyle Martin gives these seminars, right? And he says, how should you prepare gift tax returns? We have these things. The number one thing that we have in gift and estate tax returns, I prepare gift and estate tax returns all the time because gift and estate tax returns are a legal document. It's a legal document, which is your opening bid to the IRS on the values that you say all your property is worth. Who really knows what all these things are worth? Who knows what your closely held business is worth? Who knows what your rental property is worth? Who knows what your LLC is worth? It's an appraiser. They go in, they do some comparables, and they think that they know the value. There's a lot of wiggle room there. Kyle Martin says, give me your most aggressive, bona fide, reasonable valuation, because that's your opening bid. He's telling you to do that. Because when the IRS picks your return for examination, which they do for 100% of taxable estates with an estate tax return, they audit every single one. They're going to get their evaluator, and they're going to do the highest valuation, and they're going to negotiate with you for something in between. This is what the IRS is saying. Doesn't that just seem wrong? We want there to be this perfect black and white, like the government, the rules are all just really clean, and you just follow all. No, that's not the way it works.
Lawyer will have a job then.
Well, every single time they do a tax code amendment, you know what they say? We're gonna put all the CPAs out of business. We're gonna put all these state attorneys out of business. You know what they do every time? They make it all way more complicated. They create all these rules. We have more work than ever. I would love to see it complicated. Every time they do that, I'm like, please simplify it. They never do it that way. It's always more complicated. So who would consider this sort of strategy? Family business owners, people who are co-occupying, people who want to pass property. You could also sign the ballot measure when that comes up. It is coming up and it has been circulated. Bonus. I wanted to talk about the asset protection that people have with LLCs, and this applies to other states too. If you own property in Texas, Nevada, back east, wherever, you want to think about asset protection, and business entities are a great way to create asset protection. How do they do that? Is it just that you form an entity and you're protected? No, it's a little bit more complicated than that. Remember when we were talking about trusts, and trusts are a separate entity? Revocable living trusts do not create any asset protection for you. So a lot of people ask that. They say, if I put all my assets in a trust, I can't be sued, right? Wrong. People can sue you if you set up a revocable living trust. And in fact, even if you set up an irrevocable trust for yourself in California, we have a rule in California, it's not in every state, that you cannot protect your own assets from your creditors, right? You can gift assets to other people and protect it from their creditors. You can't protect your own assets from your creditors. We can get around that rule too, but it's very hard to do that easily. How, though, can you protect your assets with an LLC? This is true in California and true in other states. First of all, we set up the business entity and we have to observe some formalities. So I don't know if anybody's heard about piercing the corporate veil. Piercing the corporate veil is where you set up an entity, but it's a sham, right? You're just running everything through your name individually. You're not keeping separate bank accounts. You didn't keep the entity adequately capitalized. You haven't kept enough reserves. They can pierce that corporate veil and hold you personally liable. So you want to make sure you're checking all the boxes. You have your corporate meeting if it's a corporation. You have the bank account all funded with the tax ID number. You're doing all your business filings. You're filing your tax returns. Okay, clean. You got the CPA, you got the lawyer. They're advising you how to keep the entity. Now we got to make sure that the entity is set up correctly. The way that an LLC works is not just that it protects your assets. It's that it makes it really difficult for somebody to get to your assets. The way we do that is by drafting the LLC agreement in a particular way so that if somebody ultimately can seize some portion of that LLC, they can't actually get into any of the money in it. So the way we do that is we put in all of this language in the LLC operating agreement that says what an assignee member's rights are going to be over the LLC. So if a creditor is able to seize some portion of your LLC, they don't automatically become a member of your LLC, they become an assignee member. Now that assignee member is limited to the remedy of a charging order in California and in other states. And what that means is they have to go to court, and the court has to say, okay, anything that comes out of the LLC, you can seize, kind of like a garnishment order for wages, same sort of thing. So now we've drafted the LLC operating agreement to say that the manager, who is not the members, it's a third-party manager, right? Or it's a member who's operating as the third-party manager, has discretion to distribute or to withhold profit distributions. Most LLC operating agreements are not written this way. If the manager has discretion to not distribute the profit distributions, now all of a sudden we have the perfect storm for a creditor. The creditor has an assignee interest in the LLC, but the manager doesn't need to distribute anything from that LLC. But they're responsible for all the income taxes on the income that the LLC is distributing. How long, if you're suing somebody, would you want to wait around if you're paying income taxes on this LLC, right, every year, but you're not getting anything with that order against the LLC? Not very long. So you're going to want to settle up with that person. So that's what makes an LLC powerful when somebody's suing the LLC directly. Also, when you have an entity and it's holding real estate, you're isolating the liabilities of the LLC to the LLC. So what I was talking about before is, you get sued outside, like you had a car accident and then somebody tries to get your property, charging order protects you. If one of your tenants sues you, if you have an injury at the property, somebody at your property, I hate to say this, you can get sued for this, trips over your planter box on your property, they can sue you for negligence because you negligently placed the planter box in the range where they were going to fall on it. Always hire people with workers' compensation insurance who are licensed contractors who can avoid that. Never go under the table, always check the license, right? You want to protect yourself because you're going to be responsible for that lawsuit. But luckily, if you have an LLC and you're adequately insured with property casualty, at least it's just going to be isolated to the LLC itself. But that doesn't mean the lawsuit goes away. It just means you're isolated to the assets that are inside that LLC, which still could be substantial. So more generally, talking about asset protection, we can do other things too. I mentioned trusts could actually go to a different state that doesn't have the strict laws that California has. And you could set up a trust in that state. Unfortunately, there's some legal opinions that have come down in California that suggest that California is going to apply their laws anyway. So I don't know how much value that is, but people still do it. I don't do it personally as an attorney, but there's a lot of attorneys that swear by it. They say, well, we're trying to slow people down. So let's just create this big mess where we've got a Nevada trust, and inside the Nevada trust is this Wyoming legal entity. And so you got to go to a court in Nevada and then Wyoming. And, you know, yeah, it is a mess. But I think eventually the law actually says if you're in California, there's a lawsuit in California, regardless of where you set up this trust, they're going to be able to get the assets. I do want to mention, because people ask me about it, what if I put my assets in a Panama trust? You know, I personally don't do that. I'm not licensed in Panama. I will tell you, I have a client that had a very high stakes lawsuit. Okay. And it was an enormous judgment that he got. He's like, great, now I'm going to go collect on this judgment. It was in the tens of millions of dollars, right? This gentleman that he sued, he won the lawsuit, right? Couldn't collect on the judgment. The guy had all of his money in a Cayman Islands trust. The judge had signed an order saying, yeah, you have to pay this judgment out of your Cayman Islands trust. It's like, no, I'm not paying it out of my Cayman Islands trust. I could hold you in contempt of court. Okay, hold me in contempt of court. They put him in jail. Do you know you can't hold somebody indefinitely in jail without charges? That's actually in the Constitution. So they held him for 6 months. Pay. No, I'm not paying. Pay. No, stay there for 6 months in jail. He got out. They can't hold him indefinitely. He still has his money in his Cayman Islands trust. Now, I personally would not do that. I just, you know, I'd rather not go to jail over that sort of a point. So you may be able to preserve your money. You'd have to sit for 6 months. For me, 6 months, it's not even worth it, you know? And it kind of seems a little bit bad to set up a Cayman Islands trust too, personally. What? It's the principle. There's no law against setting up a Cayman Islands trust, but it doesn't seem like you're doing something wrong. I don't know. So I personally, but yes, that does exist. And now this is not moving forward, but I can go based upon my written slides. There you go. Yeah. Well, yeah, that's right. So, there are some states that have really favorable asset protection laws. Florida is one of the most protected. They have what's called a probate homestead over your home. California has a probate homestead too, for the first $10,000 in value of your home. So how can estate planning preserve wealth for real property owners? Now, you also want to preserve wealth for the future generations. Are we okay for a few more minutes? So is it possible, and I alluded to this before, remember how I said in California, you can't set up a trust for your own benefit and protect your own assets for your creditors? What if you could do that though for somebody else? And it's, you know, when you're going to leave the inheritance to the kids. We live in a very litigious state. The rate of divorce is about 40%. If you hit somebody, and especially if they drive a Porsche, and they're like, oh, my neck, how likely is it, do you think, that they're going to sue you? It's like 100%. Oh, my neck, right? It's a horrible state to live in and hit somebody, especially these Teslas. Just don't hit somebody in those. That's very expensive, right? And the lawsuit, it just comes automatically. So how can you protect the assets? Okay, you can set up a trust for your spouse, for children, and you can protect the assets. I just had a client. He actually passed away. His wife survived him. Before his death, he was declining. He had cancer. His doctor said, you should not drive. Very stubborn. He continued to drive. He hit somebody. They went to the hospital. They're in a coma. They slapped him with a $22 million lawsuit. We had set up his estate plan with an irrevocable trust. So his wife and children still have assets that will be able to support them. If that lawsuit had succeeded and there were assets that were not in these trusts that we had set up, his wife and children would have been destitute, right? And it would have wiped out his entire estate. So this can make an enormous difference It can also create divorce protection. But most people are like, I don't want to set up a trust like this for my kids because they're mature enough to handle the money, right? If I set up a trust for them, won't there be some bank or third party that's pulling all the strings? No, you can actually have your cake and eat it too. You can create what's called a self-directed trust. So a self-directed trust is a trust that's irrevocable, where the child or your spouse or whoever is the trustee of the trust. So they're controlling the assets, they're able to enjoy it, they're limited to what we call a HEM standard. HEM stands for health, education, maintenance, or support. Now that's not bulletproof, but it means they can use the funds for their health, their education, maintenance, or support. But if they want to have more than that, they just use a third-party trustee who will cut them a check for more. That will work. The case law supports that if they go bankrupt, if they have a lawsuit, that trust is going to be insulated from liability. My client who passed away has a trust like that for his spouse, going to be protected 100% from that kind of a lawsuit. The only thing that can't protect against is child support or criminal restitution. Sorry, deadbeat dads, you still have to pay. But everything else is going to be protected in that trust. I had a client that had one of these set up by her parent. She actually came in with her husband. The husband said, I think my in-laws didn't trust me. I think my wife should go to court and eliminate this trust. We should share everything together. We've been married 25 years. We're not going to divorce. I'm like, well, there's other benefits besides just divorce. Did you know that this is bankruptcy protection and asset protection? And actually, I think this is an act of love by your in-laws for you, because this is like your nest egg too. You know, your wife can separate this, protect this, it's going to benefit you. Like, oh, I didn't really think about it that way. And they decided to keep it and not go to court, because you can go to court and bust trusts, but we kept it. Did you know this guy was running a business, and during the pandemic, he went out of business, and they actually went through a personal bankruptcy. They lost all their assets except for that trust. They ended up retiring to the South in a much less expensive area, and they're living off of his wife's inheritance. They sent me a thank you card. So this, I saved the money. So when should you do this? What's your planning window of opportunity to put all of these great things in place that are going to protect yourself and your family? People think, oh my gosh, I've got all of my life to do this. And I also have a lot of really smart people. And they look at the actuarial tables or the life expectancy, and they're like, I'm going to die at 86. So I don't need to do this until 85. Actually, you don't know when you're going to die. That's an average. And you also don't know when you're going to become incapacitated. A lot of people become incapacitated for some long period of time. And so even though pills are keeping them alive until 86, they're not able to do any estate planning for the 10 years prior because they have dementia. So you want to do this while you're alive and well, and while you're competent. It's okay to update your plan. You don't need to have a forever plan that's your last plan that you're never going to touch. It's actually really unhealthy, because your financial life is going to change many times over your life. You're going to buy things, you're going to sell things, have kids, grandkids, you know, you may have a divorce or two. That's okay. Your plan will change with you. All right. So you want to do this early and often. So go home, set a deadline. I'm happy to talk to you or point you in the right direction. And I'm happy to answer any questions. Don't rely on any of this to your detriment. Thank you. All right. So do we have time for questions, or? Yeah, go ahead. Yeah.
The lawsuit is isolated to the LLC. So then I'm wondering if you have like a big portfolio of trade over. I've heard maybe you can put up multiple LLCs.
Yes.
And then go that up for.
That's absolutely right. So our textbook answer for that would be you set up a separate LLC for each property. Now that's really annoying though, if you've got 20 properties, right? But if you had a lawsuit and you had 3 properties in one LLC, they don't need to pierce any veil. They could just reach all 3 of those properties. So I think you plan for the worst. Unfortunately, in California, it's pretty expensive to maintain an LLC. You have to file an annual tax return, and you actually have to pay the state of California an $800 per year franchise tax for the privilege of doing business in California. Welcome to our golden state. And there's also a lot of filings you have to do. on top of all the state filings, there's also now federal filing requirements for each entity throughout the Corporate Transparency Act. They're targeting money launderers. You have to file with the federal government now for each LLC a statement saying who the underlying owner is and put the driver's license in and social security number. It might seem like simple. You know, the penalty is for not doing that. It's a $500 per day fine or 5 years in prison for not filing a form. So there's a lot of requirements for each LLC that you have. Oh, by the way, an add-on to that is you've heard of series LLCs. I used to have a lot of people that said, oh, my attorney in Nevada told me I should set up a series LLC and I can avoid all of the filing requirements in California. California does not recognize series LLCs. So you still have to separately file in California a registration statement for each and every series as if it's a separate LLC. It doesn't create any savings if you're operating in California. I think I saw a hand kind of going up over here. No, is it fake? Oh, over here. Yeah, oh, I had a slide on that. What happened to that? Yeah, that's okay. Oh, that's great. I do want to address that. That's a really important issue. Why? Because a lot of people think, what could go wrong? I'm going to name my child on the title. It'll avoid probate. I won't have to pay for a trust. It's simple. It's really easy. Let's do it. So many things could go wrong. Your child has a divorce. Do you think they're going to just leave that property and forget about it? No, they're going to fight over it and say that there's some community property ownership interest that they're entitled to. You lose your home. Your child decides they want to divorce you. As a child divorce parent, no, but they can sue for partition. And so they say, my child would never do that to me. I've seen that happen multiple times. They put their child on the deed. The child is great for 5 years, and then they marry somebody who's a psycho. And they're like, well, why don't you, sue for partition of your home? And if they came to me, I'd be like, are you kidding? Honor your father and mother. Be nice. But no, they do that. People do that sort of thing. What if they have a judgment against them and the creditor is going after the child's assets? Do you think they're just going to forget about that because you gave that to that child out of the kindness of your heart? No, they're going to go after that home. What if your child becomes incapacitated and you have to conserve them? Now half of the home is part of this conservatorship estate. You're paying for attorneys to manage half of your home. What if your child dies before you? There's a taxable transfer of those assets to you and half of the property just got reassessed. Does that sound like a good idea? Don't do it. Yeah, so many people do that. They think it's really easy. It's not easy. It's super complicated. You're welcome. Other questions? Guys, oh, okay, go ahead. Yeah.
We're probably buying assets. So you pay 1 year or whatever. How often do you recommend people update?
I love talking to people every year. That's a luxury. I will tell you with my clients, we build that into the process. We have an annual update meeting for all of our clients that have continued maintenance with us. But if you're not in that category, I would suggest talking to your attorney maybe once every 3 years. It'd be kind of overkill really to talk every year if you have a house and a bank account and a kid. But definitely more often if you're doing a lot of transactions, things are moving in and out of your trust. So you scale it based upon the complexity of your financial life. I will tell you, you don't know what you don't know, especially as you have a bigger estate, so definitely over 10 million. When the law changes, it can really affect you. So you want to be checking in with your CPA, your financial planner, your estate planning attorney regularly to make sure you're not missing anything.
Your children, how old do they? You know how.
To do lifetime gifts?
Yeah.
Yeah, and I will tell you, legally, somebody under age 18 can't hold more than $5,000 in assets, right? So you've got to set up a custodial account or a trust for somebody underage. I think we should do a trust for anybody, because do you really want to face the possibility that your child marries some psycho and then they take the assets and, they run off and then they disinherit you? Wait, I was supposed to disinherit you. You're disinheriting me. So I think it's better to put it in a trust, and then you put lots of flexibility in the trust. We use trust protectors a lot. Trust protectors are ways that you can change the trust, but it's not directly through you, it's through a third party. So if you wanted to change the ground rules, and your child could be any age, they could be 50, and you could set up a trust. But for less complicated planning, you can go up to age 21 with a custodial account. After age 21, it does pass automatically to the child when you're doing a lifetime gift through it's called a UTMA, Uniform Transfer to Minors Act account. Yeah, and the annual exclusion, where you're not having to file a gift tax return, is $18,000 per year per person. We actually do a lot of trusts, which are called crummy trusts, horrible branding. But the case that we're basing that on is Crummy v. Commissioner, which was a tax court case about 20 years ago. And they said, hey, you can use your annual exclusion and make gifts to a trust with the annual exclusion, which before that was not the case, as long as you give a notice to the beneficiary of the trust. And they say you can withdraw your gift within a lapsing period. So it can be nothing less than 15 days. So it's this very short window of time that the beneficiary has to withdraw the funds, and then we can use the annual exclusion to make gifts into a trust. It's a very powerful tool because there's no limit to the number of demand right beneficiaries that we can name in a trust. So I have before set up trusts where there were 20 different demand right beneficiaries, all of which got a notice, all of which had an $18,000 annual exclusion that they were eligible for, all of which lapsed after 30 days, which meant we took 18,000 times 20 and gifted it every single year into that trust, giving each one of them a bona fide right to withdraw the funds that lapsed within 30 days. We did that over a decade and got millions of dollars without even filing a gift tax return. Yes, that's possible. And yes, it's all approved by IRS tax opinions. Yeah. Guys, you've been a great audience. I have my contact information in the materials. Feel free to reach out. I'm going to hand it back to Jenny.
Give another round of I learned a lot today too, and there's constant change of laws all the time. So do recommend to reach out to your attorney if you don't have one. I think a lot of people filled out no for trust setups if you don't have one set up yet. So John is a great attorney here locally, and it's important to, like for me, like we set up some of our LLCs and trusts with like Nevada and all these other places outside. But for someone with your assets here locally to meet face to face felt really important. So I'm really grateful to be in contact with you. And if you have any additional questions, we'll just stay around for about another 15-20 minutes, if that's okay, if people have questions and just tidying up. And thank you for coming. Our next event will be a women's only event. It's going to be a fun one. It'll be 2 weeks here. So invite your partners if you're, but it'll be called How to Organize Your Life, Your Brain, and Your Digital Assets and Buy Back Your Time. And it will be a potluck style. So bring food if you want to come. It'll be from 5 to 7, 2 Thursdays from now on May 16th. So hopefully your wife can come. Yes. Well, thank you.